Okay, Jazakallah khair, Brother Rahman. So at this stage, I would like to open the floor for our Q&A session. So if any of you have any questions for Brother Rahman, yes, feel free to unmute yourself and ask a question. Thank you. Maybe I'll start with the question that I have. Regarding with one of the aspect of the will you mentioned was stipulating who the guardian will be. In terms of let's say Victorian law, can the guardian that you nominate be a non-Australian who is not residing in Australia, or do they have to actually physically reside in Australia?
I'm not aware of any legal requirement that the guardian must reside in Australia. But of course, in practical terms, how is a person who's residing somewhere else going to look after the minor children? And in particular, in the context of a will, where the minor children stand to benefit from the will, being in another jurisdiction may pose problems to the guardian if the guardian perceives that the executor is not administering the estate of the will properly, or not taking steps to protect the interests of the minor beneficiaries. Because if that were to happen, then in an extreme case, the guardian will have to take legal action against the executor or the trustee. So for practical purposes, it is preferable that the guardian be living in the same jurisdiction. In fact, and be under the care of the guardian, because that will facilitate looking after the day-to-day fulfilling the day-to-day responsibilities of looking after the children, knowing what they need, and the guardian will be in a better position to assess what should be done with the shares which are meant for the children. Because if, for example, there is enough for the children to live on and the surplus, then the surplus should be invested. But in some circumstances, it may be necessary to actually use that money or that asset for the current needs of the children. So a guardian who is living with the children, or at least living in the same jurisdiction of the children, I think would be in a better position to make a judgment with regard to those kinds of issues. And therefore, I would recommend that the guardian be at least living in the same jurisdiction, in the same state as the children. The question here, what happens if one of the spouse is a Muslim revert and has no children? Does his or her surviving non-Muslim parents or siblings will benefit from Fara'id? No. The simple answer is that Fara'id only, under Fara'id, the heirs to the estate of the deceased person have to be Muslim. Now, there is a difference of opinion, because remember I said earlier that we could leave up to 1/3 of our estate to someone who would not normally be a beneficiary. There is a difference of opinion whether or not you can give away that 1/3 to a non-Muslim. Okay. So I hope that answers that question.
Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh.
Yeah, I just want to, I guess, continue with Izzuddin's comment about guardianship. I think most of the I think the issues with most of the people here is we may not have other family members residing in Australia with us, so it's just this one family unit. So in the event that let's say the both parents were to go at the same time, leaving
Yep.
two young kids,
Yep.
that may be an issue.
Yep.
Second question is, so you're saying that three key persons when we make a will that needs to be stated would be who the executor is, who the guardian is, and I can't remember who, is it a trustee or the person who manages trusts?
The trustee will be the executor.
Okay, so they
Yeah.
can be anyone. They don't need to be someone with a legal background.
No, no need.
Okay.
No need. In fact, it is, if we are talking about the ordinary person, I mean, not talking about someone, say, a business person who's got businesses. If you're talking about the ordinary person, it is preferable that the executor also be a beneficiary. One is, if the executor is also a beneficiary, I'm going to pause because the connection is again unstable. If the executor is also a beneficiary, then the executor has got an incentive to administer the estate properly because he stands to gain from it, right? Secondly, if you appoint someone else, particularly if that person is a professional, to be the executor and trustee, that person is entitled to charge a commission. And therefore, you may not want the assets of the estate of the deceased. You may not want to spend any part of that estate or assets on commissions when the same job can be done by someone who will not charge a commission. Now, with regard to the other question about what if both parents pass away, leaving behind young children, I would imagine that if it is a nuclear family and they don't have relatives in Australia, I would imagine that probably the children will return to Singapore or Malaysia or wherever they came from, to live with their grandparents or to live with their uncles or aunts. In which case, then, if you want to provide for that kind of situation, then you can name a guardian who jurisdiction as alternatives. So, for example, if husband and wife are going on the Hajj, for example, or on Umrah, and they want to provide for the situation where both of them don't come back, what they should do is they should specify in their wills. The husband should specify in his will that if he passes away first, the wife or the mother of the children will be their guardian. And the husband should also specify in his will that if she passes away, the children will be their guardian. In the event that they both pass away, then you have an alternative. You could say, well, if the person whom I first name as guardian does not survive me, then I appoint the grandmother or the grandfather or the uncle or the aunt to be the guardian. So in other words, you sort of have you prioritize. The first priority will be a parent of the children, but if that parent uh, predeceases this particular parent or dies at the same time, then you have an alternative guardian who could be the grandparent or the uh, some other relative.
Okay. I've got two more questions. So, does Victorian law allow a family member in Singapore to come to Australia to be guardians? Say, let's say my sister memang nak datang kat sini tapi apa tu, but she can't because of immigration punya requirements. Tapi let's say I what do you call that? I'm nominated to be the guardian to my children if let's say both parents pass away. Then secondly is what do you call that? Is it as simple as in the will you said I want my what do you call that? What's the term? The harta to be distributed according to Far 8. Is it as simple as just that
My
one
estate.
line? Oh, estate, yes.
Yeah. Okay. In response to the first question, I don't know because that is that involves immigration regulations and policies. I would imagine that to come to Australia to look after the children temporarily, if the person has been named as the guardian and both the children's parents in Australia are deceased and there are no other relatives, I would imagine the immigration department will grant that the guardian a visa. But how long that person can stay in Australia, I don't know. I think there are schemes uh, which which would allow a person to come and look after a family member in Australia, but I do not know the specifics of those to your second question, what was it? Can you refresh my memory?
Sorry. In the will, is it as simple as I want to leave my estate to based on?
Okay. Okay, this is something which is untested. On the one hand, Australian law requires the will to be certain, to be clear. So specifying that you want your estate, you could say something like, after payment of all my debts, including whatever zakat that I am owing, I leave the residue of my estate to my trustee to distribute to my Muslim relatives according to Islamic law. You could argue that that's fairly certain, right? All you have to do is to work out at the point or at the time of death of the testator, who were the surviving relatives. You can consult an imam or an ulama, or you can get an opinion from Sharia Court of Singapore or Malaysia, or from Board of Imams Victoria, how the estate should be distributed, and then you know what the shares are. So looking at it from that point of view, you could argue it is certain. On the other hand, you could also argue someone who doesn't like that kind of distribution may argue that, well, the shares change depending on who survives the testator. At the time that the testator made the will, he had both his parents were alive, but at the time of his death, one parent has passed away. So the distribution has changed. Therefore, how is the trustee to be guided? And therefore, it could be argued that in that sense, it is uncertain. And if it's uncertain, then of course the will fails. Now, as far as I know, this hasn't been tested in court. So making a will simply like that has got its pros and cons. The pro is that you only need to determine the shares of the beneficiaries at the time of death of the testator and go at distribution. You don't have to change your will. One is that if it's challenged, I don't know what's going to happen in court, whether the court will uphold or the court will say no, it's too uncertain, therefore the distribution is not valid. To counter this, you could specify at the time that of making the will, you could look around you and say, okay, who are my relatives? I've got two parents, I've got a wife, and I've got three kids. I've got two sons and one daughter. Go to the Sharia court website, do the trial calculation, find out what the shares are, and then specify the shares in the will. That way, the will is uncertain. That's a pro. The con is that if one of these people passes away, you need to make a fresh will. Because if that person passes away and you do not redistribute, you do not reorganize the distribution, the portion that should have gone to that person but who has now passed away, that portion falls under intestacy rules. Then that portion will be divided according to state law. So it becomes complicated. So there are pros and cons. If you want to be certain, specify the shares, but if a beneficiary passes away, then you should make a new will to avoid the application of the rules of intestacy. If you want to make a general provision, there is a risk that if it is challenged, the court may not uphold the distribution because the court may take the view that it is too uncertain. Now, I need to respond to a number of messages on the chat. So,
Assalamualaikum, Cik Abdul Rahman.
yes.
Saya ada two questions.
Can I respond to the messages on the chat first? There are 6.
Mine is a short one. Just wants to confirm that if a person left a will according to the Sharia Faraid, whether the will he has written the will himself, and whether he has to be endorsed by a lawyer or a notary. Second question is, if the man has a lot of wealth, okay, and he has a will according to Hukum Faraid, but one aspect of his wealth would be his business entities. For example, he has a lot of business entities and he wants the business entities to run as per normal after his death. So what provisions can be made in the will for that issue?
Okay. In response to the first question, sorry, could you repeat the first question?
He has written a will himself.
Oh yeah, okay, whether it needs to be, okay. There's no requirement that a will must be endorsed or notarized. If you comply with the requirements that I set out in the presentation, it has to be in writing.
So who will be the witness?
Sorry?
Who will act as a witness to the document?
Anyone who is an adult, preferably not someone who's going to be a beneficiary,
okay,
can be a witness to the will, except a blind person, because a blind person may not be able to see the testator signing the will.
Okay.
The witness to be a witness, you must be then, you yourself must sign, the witness himself must sign in front of the testator. Okay. The second question that involves financial planning, which I'm not qualified to give an opinion on. I would imagine that one way to keep the business running is to organize for the business to be in two names, so that even if one partner dies, the other partner can continue to run the business. Now, that has got certain complications because part of the business will form part of the estate. Whatever part of the business which is part of the estate of the deceased person will have to be distributed according to the will or according to intestacy law. So there may be questions as to how much of the business or how much of the businesses form part of the estate and how much actually belongs to the other partner.
Is it possible for
I think for that you need to consult a financial planner and or an accountant.
Okay, I know from the Islamic perspective, let's just end this. One third is according to your wish to be distributed, and let's say the business is running on that note. Can the beneficiaries, like sons, continue the business on the joint decision making and equal distribution of profits from that ongoing concern? I mean the business entities.
Yes, you're talking about a fairly complex will where you are making a provision for the executor or the trustee to continue a going his or her own of the testator, or to continue the going partner of the testator. It is possible, but that is a complex will because it involves a fair bit of financial planning and not a simple distribution of assets after the death of the deceased. Okay.
Yeah, Jazakallah.
Wayakum. How long is the Wasiyah valid? Must someone make a Wasiyah every year? Okay. A will is valid, a Wasiyah is valid until revoked. One way to revoke a will is to simply make a new will. So when you make a new will, it automatically revokes an earlier will. If you do not make a new will, then the will continues, but there are some situations which will automatically revoke the will, and this depends on the jurisdiction. I believe in most jurisdictions in Australia, if the will was made when the testator was single, and then the testator gets married, I think if I'm not mistaken, the will is revoked. Then I'm not sure now. I'll have to check and I'll get back to you on this. Well, I'll tell the organizers. What if you make the will while you're married and then you get divorced? Whether or not the will continues or whether the divorce. But apart from those two situations, a will is valid until you make a new will. There's no requirement that you make a new will every year. You can make a will, and if you don't make a new will, or if nothing happens, the will will remain valid until the time of death. Question: can you combine both your Australian and Singapore estates in one will? Yes. A will is or properties in Australia. And similarly, if you make a will in Singapore, your will made in Singapore is not limited to your assets in Singapore. It can cover all your assets wherever they may be located. You just have to make sure that if you have certain intention over particular assets, that those intentions are clearly spelled out in your will. And then the second part of that question is, can you state in your will that you want your will to be, yeah, that was what I discussed earlier. I don't know whether specifying that you want your estate to be distributed according to Faraid. I don't know whether that will be upheld in court if it is challenged. I don't know how the court will view that kind of provision, whether the court will view it as certain or uncertain. Next question. Once a will is made, who will be keeping the will document? Okay. I recommend that you make 4 copies, at least 4 copies of the will. 1 copy to be kept by the testator. 1 copy to be sorry, not 4. 3, right? 3. Well, depends on who depends on how many people you appoint. So if you appoint 1 executor, then you should make at least 2. 1 to be kept by the testator, 1 to be kept by the executor. If you appoint 2 executors, then make 3, 1 for each executor, and 1 to be kept by the testator. If executor, then make sure that the guardian also has 1 copy of the will. Now, it is not compulsory. It is voluntary. You can register your will with the Registrar of Probates, which is a division of the Supreme Court of Victoria. So that's one way to make sure that the will can be located and the terms of the will can be ascertained if you are concerned that there may be events which may result in the loss or in the destruction of the will. Next question. Okay. The question is, there exists, if I'm not mistaken, a Wasiyah so-called association in Melbourne. Is it advisable to engage them in implementing the will for us Muslim living in Melbourne? Okay. There are in fact 2 services. I think one is simply called wasiyah.com.au and the other one is alwasiyah.com.au. Both of these are run by brothers, by Muslims, and they provide a service for you to draft your will according to Islamic law. Whether it is advisable, I don't know. I haven't engaged their service. I do not know how good their service is, but nothing ventured, nothing gained. Maybe someone can do that and then share with us his or her experience. Next question. If a single man passes away without a will, he has parents and 2 siblings, how to claim for his superannuation? Okay, that will depend on whether or not the deceased made a nomination and whether the deceased made a binding nomination or whether the deceased made the non-binding nomination, which is good for 3 years, I believe. If we are only claiming the superannuation, then get in touch with the super company and find out if you are one of the persons nominated by the deceased, then the superannuation company will discuss with you. If you are not nominated, then they won't disclose any details. But of course, you will know that the deceased has got a superannuation. What you need to do then is you need to engage a lawyer to apply what we call a grant of letters of administration. This is similar to what is known as a grant of probate. The difference is you apply for a grant of probate if the deceased left a will. If the deceased did not leave a will, you apply for letters of administration. So the immediate family members, any immediate family member can apply for letters of administration. And then once that is granted by the court, that court document will enable the administrator to approach the super fund and request the money to be released. And it will be the responsibility of the administrator to distribute the super according to the law. And of course, if the person did not leave a will, that means by default, Victorian intestacy law will apply. And if the person is a Muslim and the family members agree to have the estate distributed according to Faraid, then the administrator has to get an agreement, a deed of agreement, signed by all the next of kin, agreeing that the estate of the deceased be distributed according to Islamic law rather than according to Victorian state law. Okay, next question. For a will to be legal in Victoria, does it need to be written by a professional no. A lawyer to draft the will to enhance the chances of the estates overseas as well? Yes. Okay. Next question. All my family is residing in Singapore. How can we write a will for yourself? You can only write a will for yourself. So your family members, they have to make their own separate wills. So they should engage a lawyer in Singapore to draft the will. Each person should get a lawyer to draft a separate will for himself or herself. I have properties both in Singapore and Australia. How shall I organize wills to be distributed? According to the will, engage a lawyer or a legal professional to include in your will how you want your properties to be distributed. As a general principle, it doesn't matter where you make your will, whether in Singapore or in Australia, the will can cover properties in both jurisdictions or in any other jurisdiction, for example. Next question, does Australian Court of Law recognize Islamic law of inheritance? The answer is, well, I can approach it in courts recognize Islamic law, whether in inheritance or not, no. But like I said, you can draft a will, you can make provision in your will according to Islamic law by specifying the shares based on Islamic law, and as long as the terms are certain, the court will uphold the will, not because the court recognizes Islamic law, but because the court regards the will as clear and certain, and therefore satisfies Australian requirements. So indirectly, you could say, if you draft a will according to Islamic law, and you are able to do it in such a way that it is clear and it is certain, then if it's challenged, there's a good chance it will be upheld, not because Australian courts recognize Islamic law, but simply because the way the will was drafted, it complies, it meets the legal requirements of Australian law. And one of the most important requirements is that it must be clear and certain. Okay, so I think I have addressed all the questions on the chat.
I think if there is no other question, I think we will probably bring this session to an end. I would like to thank Brother Rahman for his time and his very informative talk. Jazakumullah khair, Brother Rahman. Just before just before we finish off as well, I'd just like to inform all of you that Amal Fund we will also be conducting another talk in about 2 weeks' time, and this is on related topic of faraid. The speaker, inshallah, will be Ustad Fahmi from Singapore. Once we finalize the details, we will, inshallah, post it so that post it on the various channels to keep everyone informed. If there's any more questions that you would like to ask Brother Rahman, you can always email us at Amalfan, either through the website or our email. Quickest way to get in touch with us is salam@amalfan.org.au. And inshallah we can forward it to Brother Rahman and get his answers. So thank you all for attending this session. And inshallah we'll see you all again at our next session. Wabillahi taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Barakallahu fiik.
Jazakallah.